you to flip to page 59 because that's an important policies chart. I'm not going to cover that in detail. I'm going to cover a lot of that through slides, but I wanted you to look at it and see that it really is packed with information about important policies that you're going to need to know about, but I've put it in one kind of 2 or 3 page document. There's a couple right at the end we won't have time to talk about. One of them is the dangerous weapons policy. Just know that students cannot have weapons on campus. You have to check them into UAPD, and employees, and that would be faculty and staff, have a different rule. They can have them in their car, but that's about the only time you'll hear about it unless the UAPD talk about it. So another one is the drug-free workplace policy. We've had issues before, not with GTAs actually, but with we have a drug-free, alcohol-free workplace, so that means you can't bring your booze to work. You have to bring your own device, but not bring your own booze. And we had an issue once with a faculty member thinking, well, it was after 5, I guess I'll let all my grad students bring their coolers of beer in and we'll just have class with beer, and that person's no longer here. So I just wanted to tell you about that one. We're not going to discuss it, but it's kind of common sense, but our business hours go until the last class taught. So a reminder of the rules. Well, I am Norma Lemley. We're going to flip back and start with the actual PowerPoint slides on page 28. But I am so happy to be here. I tell you, it's energizing for me to look out here. My passion is in higher education law. When I heard there was 32 years, I sat there and I went, I think it was 1998 when I started doing this, this training session. I've been at the university for 29 years, and you go, aren't you tired of your job? I tell you, when I look out here, that this is why I do it. I love teaching you really smart people some legal things that could get you in trouble because you don't have time to learn all that. So please do your best to pay attention. We are going to fly through this. I always have a time problem, but Lynn's going to help me with that. I am trying to teach you in 2 roles. You are a student and you're an employee. So as a student, I want you to know about these things. So if you experience any problems here, you know where to go. As an employee, you are our agent. So that means you can create legal exposure for us. We would then have to come in and defend you or help resolve the problem. So I need to train you as an employee so I can make sure you don't stumble into these areas. Also, I just want you, at the end of this workshop, I do have the most detailed slides, I will admit. It's not what you're supposed to do, but I need you to have a resource so that you can spot an issue just from having listened today. Know that there is a contact person or an office that you can go to, and just really spot that issue. And so the detailed slides and the handouts are there for you to have a resource for later. By the way, before we get started, you may want to know if a lawsuit was brought based on something that I did in my classroom, would you defend me? And my answer is yes, as long as you're acting within the scope of your employment. So our office has 5 attorneys. We've hired our newest one is our litigator. If something were to happen and you were named in a case, or the university was named but it was based on your actions, you are covered under our self-insurance policy as long as you're acting within the scope of your employment. So we'll talk about a few instances where you could lose it, but I hope that makes you feel comfortable. Yeah, okay, as long as I just follow kind of what the policies say, we're going to be good to go. I need to get my clicker here. Okay, these are the policies we're going to cover. About the first part of this presentation is going to be on this harassment, sexual misconduct, pregnant student-related policies. And that's just a really detailed outline of what we're going to cover. Then we're going to spend the last half flying through accommodating religious beliefs, accommodations for students with disabilities, confidentiality of student records. What are you going to do when parents are asking you about students? And then real briefly, alerting you to a handout on ethics. So state ethics code says that you can't use your position for personal gain as a state employee. So if I don't get to it, there's a nice 4-page handout. We give it to all the new faculty just to kind of give you some 20 or so tips of don't do this, don't do that, so that you don't violate that ethics law. And the big thing about the ethics law is that it is a criminal law. And we can't come in and defend you if it's an ethics violation. So if we don't get to that section, please read that handout that I've provided for you. All right. One thing I wanted to, we're going to talk about some sensitive issues, as Kathy indicated, and sexual assault, domestic violence, dating violence, stalking, those kinds of things. And those are sensitive issues. In a room this size, someone has experienced, and more than one has experienced in a room this size. So I'm asking you today to just, as we hear this, we'll watch a little video clip, if it works. I forgot to check that. And I'm just asking you to please be respectful of the fact that people in this room are likely to have experienced some of the things we're going to talk about, and that could be a painful experience for them. The things that I'm talking about just may provoke a negative reaction from them. So if you're in the room and that occurs, I want you to follow up and go see our Title IX office, or more importantly, our Women and Gender Resource Center, who has victim advocates, counselors, a wonderful staff over there to provide some assistance. And my materials have contact information for that. I tend to just go straight into it. I don't tell jokes. I'm just matter-of-fact Norma. We get through the legal issues. So I hope that's not offensive to anyone. We're just going to talk very matter-of-fact about the issues. Because I need to make sure, as I indicated earlier, as an employee, you're not exposing us, and as a student, you know your rights. So please be respectful of individuals who may have suffered some of the things that we're going to talk about. All right. Another reason why I want you to listen today is because there are consequences of you not listening and not following. I've had two legal issues in my 29 years here that were caused by GTAs who failed to attend the GTA training session. If they had just been here, they would have been able to avoid that. So we definitely want to avoid lawsuits, which is one of the bullet points on here, but we want to avoid criminal prosecution. Some of the violations, the ethics codes, could lead to criminal prosecution. Reputational damage for the university. You could lose your employment and the GTA benefit that you have. Their code of conduct sanctions up to and including expulsion. We could have an investigation by a federal agency, and these are just some of them: Department of Education, Office of Civil Rights, Department of Justice, the Department of Education's Office of Chief Privacy Office. That's the one that regulates our confidentiality of student records. The university could lose all of its federal financial assistance. That would be one of the worst outcomes. You could face civil litigation, and my examples are all the laws that I need to know about. You don't need to know those, but I've already pointed out that we provide a defense to you as long as you're acting in the scope of it, of your duties and not blatantly violating our policy. One example of where you could violate that and lose your coverage would be, we're going to talk about a consensual relationship policy. And if you violate that policy and have a consensual relationship with one of your students, you're the one with authority. Your students have no authority in this situation. You think it's consensual. Later, a year later, the student comes to the Title IX office and says, I was in this relationship, but I felt pressured. I needed a good grade. I needed the reference, whatever. I didn't feel comfortable because of that power differential. We're not going to provide you a defense in that situation. Why? You were acting outside the scope of your employment, and you blatantly violated a policy. So that's just an example, and unfortunately has occurred, and we've had to have faculty members who didn't hear that message have to pay for their own legal defense, and that we're talking $500,000 in legal fees to go through a trial like that. So if I'm boring, please pay attention to me, because I don't want you to have to experience that. There's incredible cost and disruption of litigation beyond the monetary, and obviously the damages. So with that, now hopefully I've got your attention. Let's plow through some substantive law, okay? So the university has an equal opportunity, non-discrimination, affirmative action policy statement. We're required as a federal contractor to have that. We prohibit discrimination on all of these protected bases: race, color, religion, national origin, sex, sexual orientation, gender identity, gender expression, pregnancy, age, disability, protected veteran status, and any other legally protected status in our admissions process and in our employment. Okay, so that's our statement. That's our non-discrimination. We also have an anti-retaliation policy. If you bring forth a complaint about somebody harassing you, violating, discriminating on any of these protected bases, the law requires, and our policy is very clear, you cannot be retaliated against because you brought that complaint, even if ultimately we find that there wasn't a harassment violation. You're protected from just bringing it to our attention so that we know and can look into it and investigate and determine. It might be one off-color joke, and that may not rise to a level of a violation of the policy, but we need to know about it so we can go and talk to whoever did that and do some education and corrective kind of counseling so that we kind of nip it in the bud so it doesn't ever get to a severe and pervasive environment. So it's really, really critical that you bring it to our attention. A lot of people are afraid of doing that because they're afraid of what might happen, and I'm telling you, the law and our policy protects you. The number one charge in the United States since 2009 has not been race, gender, disability, age discrimination. It's retaliation. The number one charge. We take it very seriously. So just know that you can bring anything to our attention and you will not be retaliated against. We have an affirmative action program that invites people to tell us whether you have a disability or whether you're a protected veteran, and we do that because we have to report that back to the federal government. And we also provide reasonable accommodations to individuals with disabilities. So that's our overall statement. We have an incredible resource on our website called UACT. It's the full name of it, but on your handouts on page 56 is one chart that I would like you to just remember. I walked into an administrator's office recently and it was pinned on the bulletin board and I was like, yay, high five, great job. This chart will tell you if you're experiencing this problem, whether it's hazing or discrimination, or you're a pregnant student and you need to go get accommodation, if you have a behavioral threat assessment, it's a one-stop shop, a one-page, two-sided resource for you that's on the web in case you lose your notebook to tell you if this is happening, here's who you contact. We're not going to go through all that chart today. I want you to know how critical it is. If it's ever updated, it's updated on the website. So you could type in UACT at the UA website and you'd find it first hit. You'd go to the website and then it'd say a chart, and then you click on the chart. But that's a very, very important document for you to have, not only for yourself, but remember, you are closer to these students than our offices will ever be. We're the central administration and we're kind of intimidating to an 18-year-old. You guys are right there in the trenches with them. You're the ones who are likely to get them to tell you something that's going on. That's the chart you need to be able to hand to them. Make sure they know about it. It will really, really help us. So it has a lot of information, and that's really the point of this slide. So let's move to the next one. We have a law in the state of Alabama since the Penn State matter that many of you are aware of that makes higher education employees in the state of Alabama mandatory reporters of child abuse and neglect. So all of you are on our payroll, so you are all mandatory reporters. A child, for the purpose of this statute, is age 17 or younger. You might have some freshmen in your class, or you may be working on an activity, a summer camp or a spring camp or whatever, where we bring minors on campus. If we learn, if you become suspicious of child abuse or neglect that's occurring in our university activity, whether it's on campus or off campus, it is a mandatory report to UAPD 348-5454. You have to report it. If you don't, you're in violation of the law, and you can be charged with a felony. I mean, not a felony. I'm sorry, a misdemeanor, and 6 months in jail or up to $500. So good news is the statute in Alabama says, you know what, you're protected against retaliation. And guess what? If somebody tries to sue you because you reported and it didn't turn out to be child abuse or neglect, you're absolutely immune from that lawsuit. So you're protected all the way around. Some people come to me and say, well, does this situation fit? And I said, I'm not the judge of that. If you have any inkling that there might be child abuse or neglect, you contact UAPD, 348-5454. Let them decide whether it meets it or not. You're protected from a lawsuit, and you're protected from retaliation. So very, very important mandatory reporting statute. We also, as we're talking about minors, a couple years in 2017, we decided that, we have a lot of kids on campus who are here every day of the week. I think Marcy Huey is our compliance director over summer camps. I think, 100,000 kids on this campus under the age of 17 every year. We decided we needed to start registering those events. So if you are working on a project where you're going to bring minors to campus, there's a registration process. We're going to be background checking everybody who's working with those kids. You're going to learn some policies and procedures. You all have to go through all the mandatory training for the youth and child protection. Let's see, it does not apply for 17-year-olds in your class. Obviously, that's already approved. It's these extracurricular kinds of activities. But if you're planning on doing that, you need to give them about 8 weeks advance notice to start that registration process, because it takes that much time to get all the pieces in place. Make sure you're properly insured, make sure all the right people are on the staff, don't have a background that causes concern to us. That's the point of that. All right, we're going to start talking about our student code of conduct and how important it is for you to know it as an employee. So if you're dealing with a student who needs to know about this because they're a victim, you can direct them to the right place, or you as a student have experienced issues, you know how to file a complaint and what's going to happen. I give you the website to the code. I know it's a long document, so you're unlikely to read it, so I'm going to try and summarize it. It does cover on-campus and off-campus activity, okay? So it's not just something a student does on campus. We have jurisdiction if a student violates our code off-campus. Our policy, our code of conduct says that if you violate any of these listed policies or any university policy, I just list the ones that are the most problematic, then you're subject to discipline. Our sexual misconduct, which we're going to talk about, hazing, harassment, child protection, we just talked about, the drug-free campus and workplace policy, I mentioned that earlier, dangerous weapons and firearm policy, I mentioned that earlier, and then OIT policies. You're in the dorm and residential life and you're downloading a bunch of copyrighted materials and sharing it and, violating, the inventor's or the author's rights. You can get in serious trouble for that. Also, and I don't think it's on my slides, but there are provisions in the code of conduct that say if you're disrupting the educational process, that's a violation of the student code of conduct. So if you have a disruptive student in your class who is not allowing you to get your material out, and you've warned them and you've had discussions with them afterwards, and they continue, you've got a code of conduct charge, and you think that's so harsh, but sometimes that may be the best avenue to get them into some counseling center, some other treatment. We're not so much a punitive as much as an educational. We're not a criminal justice system. We're a system that tries to help the students learn to maneuver this new environment. They're at a young age. Yes, there are some things that they can do that could get them expelled and suspended, but disruption in class is something we can deal with. And if you need to have to go the code of conduct route, know that that's another provision in there that could help you. The process is that any member of the university community can file a complaint against a student for misconduct. Non-UA members with direct knowledge or information can participate as witnesses. If you bring a complaint, they have an online complaint form now, but you can also prepare one in writing and send it over to the Office of Student Conduct. The director there is Todd Borst. We have a lot of investigators in that office. We don't have a strict statute of limitations, but obviously the longer somebody waits, the less likely we're going to be able to do something about it, because you lose the ability to give good, clear, clean, uncontradicted evidence the longer you wait. So the big message here from the whole day is act promptly. You can't sit on it. If you know a child abuse or neglect, you've got to act promptly. These other things that I'm going to talk about, you've got to act promptly. Same thing here. We encourage students to just go ahead and if they have a problem, or if you've got a problem with the student, go ahead and bring it to the attention of that office. They would like it preferably 30 calendar days. I'm saying that's too long. That's too long. Act promptly. If we have stalking or domestic violence or dating violence or sexual assault, there's no statute of limitations on that at all. Obviously, the sooner we know about it, the quicker we can take some action to stop that behavior. The student code also has some provisions about harassment of a non-sexual nature, threatening behaviors, and bullying. This gets real detailed, but basically you're directing some conduct towards someone based on their race, color, religion, national origin, age, disability, all those protected statuses we talked about. It's got to be sufficiently severe, pervasive, and objectively offensive that it would interfere with a reasonable person's ability to participate in or obtain the benefits of one of our activities. Also, the code says any attempt to intentionally and repeatedly make contact with a person over their stated objection, that's going to be a stalking charge. An act that invades the privacy of another, let's say you're videotaping two people without letting them know, and they had a reasonable expectation of privacy. Many years ago at another school, there was a roommate taped, I think it was out of New Jersey, a roommate taped his roommate having sex with another friend, and it was publicized all over the internet, and that young student committed suicide as a result. That's a very serious charge that you can face, and he did face murder charges after that. Threatening behaviors, written, oral, or physical conduct that creates reasonable expectation of injury to health or safety of a person or damage to any property. And then bullying or cyberbullying, that can get someone in trouble with the code of conduct. We also have a hazing policy, so that's any inaction, situation created or communication that recklessly or intentionally harms or threatens the mental or physical health or safety of a person, or any act that removes property for purposes of initiation, admission into, or affiliation with the group. These are your big band, cases out of Florida State with the band hazing. You can have it in the Greek system. You could have it in any of your clubs. We need to let everybody know that is a violation of policy. It is a violation if you know about it and you don't report it. Sexual misconduct. Back in 2011, the Department of Education put a whole new emphasis on this. So this, in my 20 years of training, this has now become the hot topic. But sexual misconduct is going to include your stalking, domestic violence, dating violence, rape, statutory rape, sexual contact. You can read the slide. It's all those things. Any sexual acts that occur without the victim's consent, or that occur when a victim is not in a state that enables them to give consent. So some examples of non-consensual sexual exploitation: you cause incapacitation of someone else for sexual purposes, you're electronically recording, photographing, or transmitting sexual sounds or images of another person, you're allowing a third party to observe sexual acts, you're engaging in voyeurism, you're knowingly transmitting a sexually transmitted disease or infection or HIV to another individual. So those are listed in the code, and I wanted to bring those to your attention. Sexual assault and rape is defined in our sexual misconduct policy. It's any form of sexual penetration or attempted sexual penetration without consent. We give a definition of coercion. There's sexual contact and fondling and sexual touching. All those are defined, and I'm just giving you a short description of what those are. The big issue in most of these cases is, was there consent? So it's very important that you know, so that you can help a student who's coming to you, and so that you know for your own benefit. Under our policy, consent is a clear willingness to participate in the sexual act, and that's clear communication through either words or actions, and we recommend verbal words. It's the initiator of the sex It's the initiator's responsibility to obtain the partner's consent. The fact that they consented previously is not clear consent to future sexual acts. It can be withdrawn, and lack of resistance does not mean you've consented. There is no consent if you're incapacitated. Doesn't mean that you had a drink. It means you're incapacitated because of alcohol, drugs, or prescription medications. Our Title IX officers are fantastic. We have a great staff. They have a very difficult job because it's their job to determine whether or not there was consent. And they're going to look at a totality of circumstances. And I just list some of those things that they will consider. But if you're unconscious, asleep, ill, or in a state of shock, you cannot have given consent. If you're mentally or physically impaired, you're not able to give consent. And in the state of Alabama, if you're under the age of 16, you cannot give consent. So this is the part I did not check to see whether it worked. This is a little YouTube video that hopefully is going to work for us. That gives you just a
If you're still struggling with consent, just imagine instead of initiating sex, you're making them a cup of tea. You say, would you like a cup of tea? And they go, oh my God, I would love a cup of tea. Thank you. Then you know they want a cup of tea. If you say, hey, would you like a cup of tea? And they're like, I'm not really sure. Then you can make them a cup of tea, or not, but be aware that they might not drink it. And if they don't drink it, then, and this is the important bit, don't make them drink it. Just because you made it doesn't mean you're entitled to watch them drink it. And if they say, no thank you, then don't make them tea at all. Just don't make them tea. Don't make them drink tea. Don't get annoyed at them for not wanting tea. They just don't want tea, okay? They might say, yes, please, that's kind of you. And then when the tea arrives, they actually don't want the tea at all. Sure, that's kind of annoying as you've gone to all the effort of making the tea, but they remain under no obligation to drink the tea. They did want tea, now they don't. Some people change their mind in the time it takes to boil the kettle, brew the tea, and add the milk. And it's okay for people to change their mind, and you are still not entitled to watch them drink it. And if they are unconscious, don't make them tea. Unconscious people don't want tea, and they can't answer the question, do you want tea? Because they're unconscious. Okay, maybe they were conscious when you asked them if they wanted tea, and they said yes, but in the time it took you to boil the kettle or brew the tea and add the milk, they are now unconscious. You should just put the tea down, make sure the unconscious person is safe, and this is the important part again, don't make them drink the tea. They said yes then, sure. But unconscious people don't want tea. If someone said yes to tea, started drinking it, and then passed out before they'd finished it, don't keep on pouring it down their throat. Take the tea away. Make sure they are safe, because unconscious people don't want tea. Trust me on this. If someone said yes to tea around your house last Saturday, that doesn't mean they want you to make them tea all the time. They don't want you to come around to their place unexpectedly and make them tea and force them to drink it, going, but you wanted tea last week, or to wake up to find you pouring tea down their throat going, but you wanted tea last night? If you can understand how completely ludicrous it is to force people to have tea when they don't want tea, and you are able to understand when people don't want tea, then how hard is it to understand when it comes to sex? Whether it's tea or sex. If you're still struggling with consent, just imagine instead of initiating sex, you're making them a cup of tea.
I'm so
You
sorry,
say,
y'all.
hey, would you like a cup of tea? And they go, oh my God, I would love a cup of tea.
Okay, y'all got the point. So sorry. Okay, there we go. And now I need to get back to where I was. Okay. Okay, thank you. Y'all can tell I'm one of the older ones in the crowd. All right. Great video. Important point about consent. I want to go real quickly because I can tell I'm running low on time here. What to do if a student confides in you regarding a Title IX violation. They're telling you that they've experienced this, they want to miss class because of it. You're not getting information from the Title IX office, you're getting it straight from them. What are you going to do? You are, under our policy, what we call, and under the law, a responsible reporting official, RRO, responsible reporting official. You are a mandatory reporter. So you're going to need to tell them, hey, I'm a mandatory reporter. Even if you want to keep this confidential, I can't keep this confidential. I have to go tell the Title IX office, okay? You can tell them, and this would be very helpful, if you tell them, look, you can pursue criminal action, you can call UAPD. That's one route. A second route, and you can do all three of these, is to contact the Women and Gender Resource Center, because that's a safe place where you can go to have a totally confidential conversation. Our office will never know about it. Title IX will not know about it. If you just want to go get help with how to deal with it, you don't want to prosecute or you don't know, go to the Women and Gender Resource Center. They've got to understand that is the confidential place that they can go and get resources. We have incredible staff there to be able to help, trained victim advocates, incredible resource. So make sure that they know about that. And then they need to know that you're going to have to contact the Title IX office. Why? Because you're a Title IX, you're a mandatory reporter, okay? So you just really don't have a choice in the matter. Now, you all are students. That does not mean that as a student, in your student capacity, your friend is telling you this. This means you're in that weird position of you're a dual role. It's when you're an employee. So if someone's telling you because you're a GTA, it's one of your students, or somebody who's holding you out as being someone who has authority, then that's when you're the mandatory reporter. It's not your roommate telling you who's not in your class or in any of your responsibility. But please help us avoid, we are in huge trouble with the Department of Education and facing Title IX lawsuits if you get information and you do not move fast and get it to our Title IX office. And I mean the day of. We're not waiting a day or a week. We're talking immediately. You finish your class, whatever, and you make that contact. Other information you should know, you are not required to report incidences communicated as part of your routine academic experience. So you ask them to write a paper on something, they write this gut-wrenching ordeal that you really had no idea that you were going to be reading this. That is not a reportable offense unless the student clearly states they want a report made. So research projects, application essays, awareness events, we'll have several awareness events during the school year. And people will tell their stories. Those are not mandatory reports, and that's because the regulations say so, okay? You want to remind the student that reports to the Women and Gender Resource Center, and I want to tell you some others that you could also send them to, but the experts on this topic is the Women and Gender Resource Center, but you could send them to the Counseling Center. They could go to the Student Health Center, Psychology Clinic, our Autism Spectrum Disorders Clinic on campus, and the UA Law School has some law clinics to help with restraining orders and things like that would be free to our students. So those are confidential places that they could go. I don't want you to be the counselor, though, on all this. Your job is only to get them to the Title IX office. Believe me, they will cover all of this. And if they don't want to go to the Title IX office, get them to the Women and Gender Resource Center or tell them about it. It's their choice. You cannot force them to do anything. It is the complainant, or we call them, we don't like to use the word victim perpetrator, we use complainant and respondent. It's the complainant's choice as to how they want to handle this. We do try and keep that information as private as possible, but if this is the third time that we are hearing about that respondent, then our Title IX coordinator will make a decision. I know, complainant, that you don't want me to move forward, but this is the third time. I have a duty to keep the rest of the campus safe, and so we're going to have to move forward whether you want us to or not. That is rare, but if it comes up, and again, our Title IX coordinator is telling the student about that. Things that happened off campus a long time ago still report to the Title IX office if they're telling you in the official capacity. There's no time limits in our sexual misconduct policy. The Title IX office will decide, do we have jurisdiction or not? And even if there's no jurisdiction, we're still going to be able to help the student with accommodations, because even though the respondent might be someone totally not associated with our campus, so we really can't do anything to the respondent, there are things that we have that we can help the student because that experience has impacted their student experience. So it's very, very important that we get them to the right resources. Otherwise, they're wasting a lot of tuition money and time because they're not able to think clearly because we haven't provided those resources. So you are a critical part of that knowledge for our students. Again, you don't conduct investigations, and there is some training. We call it Bridges now, training for faculty, staff, and graduate school employees. I think it's assigned to you, and so you want to make sure that you take that training. You may also get contacted by and get an email from the Title IX office saying, hey, Susie was out of your class on Tuesday because she was in our office. You go, what do I do with this? Well, follow what the Title IX coordinator said. If they're asking you to excuse them from class, you don't, one, presume that they're a complainant. You don't presume they're a respondent. They could have just been a witness. You don't know, and you don't ask questions about it at all. If you're concerned about, is this an authentic, real email, call the Title IX office, and they'll tell you whether or not they sent it. That's about all you. So just pay attention if you get one of those. Don't let that go into your junk box. Another big issue is making sure that our students who are pregnant, and that may mean some of you in this room, understand that you have some rights, and you as a teacher need to understand that you can't penalize a pregnant student. So Title IX is the statute that also protects students who are pregnant or have had false pregnancies, termination of pregnancies, gone through childbirth, or recovering. So we can't say, sorry, it's a PE class, you're pregnant, you can't be in there. Or, I got a chemistry lab, there's some dangerous materials in here that might harm your baby. I'm not gonna let you in the lab. That is not your choice. They have the right to be in that lab. You can't require a doctor's certification that they're fit to be there unless we did it for everybody else. We've got to provide the same services to a pregnant student as other students with temporary disabilities. And if you're feeling harassed or know of harassment based on pregnancy, then report that promptly, immediately to the Title IX office. Some accommodations that you need to provide pregnant students is they may have to have their tests rescheduled. You have to excuse their absences. Even if your policy on your syllabus is, 5 absences and then you drop a letter grade, if those 5 absences for the pregnant student are due to pregnancy or pregnancy-related condition, those don't count. You can't reduce a student's grade because they missed because they were pregnant. You have to give the student a reasonable opportunity to earn back the credit missed due to the pregnancy and provide alternatives to make up missed work. Really critical stuff. We have some FAQs online if you want some more information. The main point here is go to the Title IX office. Send any student who you know is pregnant who needs some accommodations to the Title IX office. What's happening now, because we're getting the word out, is they're going ahead and going, they know that they're pregnant, and now they're going ahead and kind of working with the Title IX office to set up. And Title IX office then reaches out in advance to the teachers and says, okay, you're going to have a pregnant student in your class, and I want to remind you what the rules are. That's very helpful for us to avoid any liability. Huge, hot topic. It can be a huge legal exposure if you get that wrong. We've talked about sexual misconduct, the student code of conduct, pregnant students. We also have a harassment policy that deals with the non-gender based. And it also includes, it just existed at the university longer than the sexual misconduct policy. But it has a non-tolerance statement, defines what harassment is, requires you to promptly report it. It identifies, if you go to the UACT chart, it tells you who our designated harassment resource persons are for each college. That's the way we want you to report non-gender-based harassment, is go to your designated harassment resource person. So there's a whole list of them online. They change over time. That's why we don't name them in your handout, but that's the website. And just like in the sexual misconduct, we're in every other policy, we're assuring confidentiality to the extent that we can, and non-retaliation. It does, our harassment policy covers all protected statuses, so we've kind of covered those in our equal opportunity program. Some examples would be sexually explicit statements, sexually suggestive comments, jokes, innuendos, unwanted touching or sexual advances, displaying sexually graphic materials, offers for or demands for sexual activity in exchange for perceived benefits. You can't say, hey, you sleep with me, I'll give you a good grade. That's just a big no-no. Public lewdness. Gender harassment would be unfair treatment directed toward an individual or group because of their sex or gender. Written, verbal, or electronic statements that disparage a person based on their perceived gender, sexual orientation, gender identity, or gender expression, or you just don't let them in your program based on that. Other types, the list goes on. I think you all understand what harassment is. Word of caution on social media. As a GTA, you're used to, in your student role, having all your friends on all your, I'm too old to list them all, your social media avenues. We've had issues in the past where GTAs have invited students to participate in that social media life of theirs. And it's created problems when you are putting information up on there that is, in one particular case, very sexually explicit, and it wasn't quite illegal. It didn't meet the definition of obscenity, but it was sexually harassing if you put it on the classboard every day, or chalkboard every day. So this slide is mainly me kind of being a mama here and just saying, look, you're like me. You are an at-will employee. I can be fired for a good reason, bad reason, or no reason at all. I have no tenure here. I've been 29 years. You do the right thing, you're fine. But you could lose your job if you're pushing the envelope with what you do on social media and you're inviting your students to participate in it. The university has just released a diversity video, and at the end of that diversity video, and I'm sure it'll be circulated and you'll get a chance to see it, but they talk about, to students, using the acronym THINK before you post. T, is it true? H, is it helpful? I, is it inspiring? N, is it necessary? K, is it kind? I loved that. I love that in that video. That's really the point I want to make here. Be careful. I'm not trying to step on anybody's academic freedom or free speech rights. I'm trying to tell you, you are just like me, and we don't have tenure, and I just wouldn't push the envelope. Confidentiality, we're going to maintain it to the extent that we can, but obviously if someone's accused, they have due process rights, so we have to let them know who the complainant would be. If someone requests confidentiality, we still have to take reasonable steps to stop whatever is happening. So we can't just hear it and do nothing, and that's why we have to tell other people. It's all in a very limited need-to-know circle. And again, you want to remind students that they can get confidential counseling. I hope I have hit over and over again anti-retaliation. This is also in our harassment policy. It is against our policy and the law to retaliate against anyone who complains of harassment based on these protected statuses. And for students, that could mean your grade was lowered, you refused to give a recommendation, you're reassigned to some other group, you refuse to rehire a student as an employee because they complained, etc. For employees, you could lose your job, be demoted, whatever. We can't do those things simply because you brought a complaint. All right, our policy on consensual romantic relationships. I said you could lose coverage. I just want you to realize it is not against the law. It is not sexual harassment to date your student. That's not the problem. Why? Because it's consensual. The problem is that power differential I talked about. And because of that power differential, and because students can come back and say it really wasn't consensual, we at the university have a policy that prohibits it. I'm telling you, we have watched department chairs in a relationship with a graduate student lose coverage and have to defend themselves at the table in the courtroom and pay those, won the case because in that particular situation, the victim was really a department chair, was a vulnerable victim, vulnerable department chair. Should have known better. We had a consensual relationship policy. Do not date your students or anyone else who you've got authority over. Otherwise, you're on your own from a legal standpoint, and I just don't want that to happen to you. So be aware we do have that policy. It doesn't mean you can't fall in love with somebody in the biology department if you're in chemistry, okay? Or that you found your wife or husband to be in your class, but nothing is going to go on, ladies and gentlemen, nothing is going to go on while you have authority over that student. Okay, later after it's all said and done, you can go get the number, but not while you're the one. We are not the love police. We love you to love. All right, so I think I've made my point on that. The other thing I wanted to point out about our harassment is hostile environment has to be balanced against academic freedom. Okay, so there's this case out of, I forgot where it's out of, Bunnell Macomb Community College. So this professor taught English literature and had the right to teach some sexually explicit literature. It was germane to the course content. The problem is he started ostracizing the students because he'd bring up his own personal sexual experiences and want the students to describe theirs. Totally got off the point with the literature. When the students complained about it, then he ostracized them. So the university disciplined him, he sued, and he lost, thank goodness. And the bottom line is the last bullet. Academic freedom, which is what he argued. I've got free speech rights. I'm the teacher in the class. I can teach whatever I want. Not whatever you want. There are limits, and you can't create a hostile learning environment. So the academic freedom cannot compromise a student's right to learn in a hostile free environment. The professor's speech must be germane to the course content as measured by professional standards. That's the case law. That case law is sort of codified in our harassment policy, and that's the language that's in the actual policy. So let me move on. Clery Act, I wanted to just briefly mention that. For those of you, anyone want to, maybe too early, if you are going to be an advisor to a student organization, raise your hand. Anyone, an advisor to a student org, or you might, if you become one, I see a couple hands. If you are an advisor to a student org, then you have a responsibility. If you learn about crimes, if somebody reports a crime to you, you have a responsibility to contact our Clery coordinator and tell them about the crime you heard about. Don't worry about what crime. I'd rather you just report it, okay? You can go to the website to see what the crimes are. The picture of this young lady on the slide is Jean Ann Cleary. This is a young lady who was murdered and raped in her dorm room at Lehigh University in the late 80s. And as a result of her parents not knowing what kind of environment what crimes occurred in the area of the school, we now, since then, all higher ed institutions have to file annual security reports and report accurately and all the crimes that are reported to us. It doesn't matter when the crime occurred. So this is a very important statute. If we don't get this right, $54,000 per violation. It's important if you're going to be doing anything with student activities and you're the adult in charge, then you have to make these reports, and that gives you the information on that. All right, accommodating students, student and employees' religious beliefs is this next section. Just a couple slides on that. We have posted some guidelines on the Provost website. I'll give you the website to it, and basically if you just read this slide, you'll get it. Faculty are required to make reasonable efforts to accommodate sincerely held religious practices and observances of students unless the accommodation would create an undue hardship on the university. The guidelines say, look, we've got a schedule. When you're scheduling your exams, you may want to take a look at the religious holidays on the interfaith calendar that's online and just be aware of that. You need to include on your syllabus, and if you use Lorne's, Office of Institutional Research and Assessment, if you use the online syllabus tool that you'll learn about if you haven't, and you have to use that tool, it's already pre-populated. This statement's already on there. You don't have to worry about it. But that students should notify faculty in writing or an email in the first 2 weeks of the semester of their intent to be absent from class for religious observance. And then faculty, you need to provide students who gave you that notice and are absent a reasonable opportunity to complete the academic responsibilities in the original or alternative form without any penalty, unless doing so would interfere unreasonably with the academic integrity of the course. If you two can't work it out, student and teacher can't work it out, then the student can file a grievance. If you are an employee, because you're both, and you need an accommodation in your employment capacity, then we have kind of a one-stop shop, and I give you the website that if you need accommodation for disability, religion, or pregnancy, you go to that website and then they'll break it down. Okay, if it's pregnancy, click here. If it's religious observance, click here. If it's disability, click here. And basically, same rules apply. We provide reasonable accommodations for employees' sincerely held religious beliefs unless it would impose an undue hardship. The way you do it as an employee is you fill out the form that's online. Okay, So I just want you to know that's available. And all through this, employees have to engage in interactive dialogue with our HR partner for that department, because sometimes it may be shift work. That's usually not your situation. It's going to be whether you're going to miss a class or not. But realize that those are there. All right, we're going to start flying. Students with disabilities. Your little legal lesson for the day. So the Americans with Disabilities Act, the ADA, and Section 504 of the Rehab Act in 1972 requires that students with disabilities who are otherwise qualified must receive reasonable accommodations and are protected from discrimination, harassment, and retaliation. Okay, that's what those laws, and every time the words are in quotes, there's like a million cases determining what those words mean. For your point here, you don't determine whether a disability exists. I don't get to do that. There's an office on campus, the Office of Disability Services. They're going to gather documentation from the student, and they're going to make a decision whether or not there's a disability that entitles them to a reasonable accommodation. They will then prepare, ODS will prepare an accommodation notice and then give it to the student. The student is then going to bring it to you. Your job is not to argue with the student, discuss it in front of everybody else. That was one of the GTAs that caused legal liability. That's exactly what happened. Didn't know about ADA, got this notice in front of all the class, started arguing that no special accommodations were going to be given to her students, and violated FERPA. It was awful, awful, awful. We resolved it immediately because we were wrong, and then we got that person some training. So don't discuss this in front of everyone else. If we need to make a schedule an appointment with the student to discuss it, do that. But it's not your job to ask about the disability, and I beg you don't do that. Because if you don't know what the disability is, it's hard for you to discriminate against somebody based on that disability. All you know is that this office has told you to provide a reasonable accommodation, and all you have to do is do what they've asked you to do. A student also has to be otherwise qualified, so they have to meet the essential functions of being a student. So in other words, we're not going to lower our academic standards at the university. That is not a reasonable accommodation, okay? They have to meet the essential functions of our admission criteria. They have to comply with essential attendance policies. They have to comply with our honor code. There's a case out there where somebody plagiarized and said it was because of my disability. The court said, no, you're not otherwise qualified as a student. We don't have to accommodate you violating the honor code. And then you cannot threaten the health or safety of others, and you're going to get some speakers on that later today. So once you have a disability and you're otherwise qualified, then the law says we've got to provide reasonable accommodations. So this slide sort of tells you all the types of reasonable accommodations, and in your context you might be looking at time and a half on test, distraction-free testing environments. You might have an interpreter. You may be asked to give your PowerPoint slides, whatever. This slide sort of covers that. If your office is inaccessible and the student needs to meet with you, you need to figure out another place for you to meet, and I would wisely encourage you not to do it at your home or at midnight or at the bar, okay? So we got those other statutes we talked about. We don't need to do that. Very free. So if you're disabled, you're otherwise qualified, we now have to give you reasonable accommodations. There's very, very few circumstances where we can deny that, okay? Fundamental change in the program or activities, that's not going to be something you're deciding. It's got to be an unreasonable cost to the institution. We got $1 billion in the budget of the university, so that isn't going to fly. And it's not, it costs you money or it costs you time. It doesn't matter that it costs you time. We have a duty to do it. And we have a testing center on campus where you can send the students with disability services can take their test there to get the time and a half. If that doesn't work because all the slots are filled, it is your responsibility. It is not ODS's responsibility. I can't emphasize that enough. It is you are the teacher. It is your job to make sure the accommodation is provided. We have an office who can help you do it, but the responsibility didn't transfer to them. It is your responsibility. All right, some tips to avoid legal exposure. I'm going to fly through them, but if I give a lot more detail on page 46 in a handout, really just taking you through these tips so that don't worry that I'm flying because you've got it all in writing. So you don't get to decide if there's an accommodation or a qualifying disability. You just comply with the notice that is brought to you. Those are the first two. Don't discuss it in front of others. You want to avoid that lawsuit. Don't ask the student how it happened. You don't get to know what the disability is. Do discuss with the student how you're going to make this work, okay? So if it's time and a half, where's that going to happen? Is it going to be in the testing center? Is it going to be in your office? How's that going to work? And make sure you have that dialogue. And the law requires that dialogue, okay? So you're the adult in charge. You're going to have to lead that process. Do include a statement on your syllabus about registering with ODS if that's already pre-populated in the online syllabus. Don't ignore the recommended accommodations because you personally disagree with them. You have an appeal process if you feel really strongly about this, but while that appeal process is going on, you have to provide the accommodation. You will expose yourself to civil liability right here. This is a very important, very important statute that gives a plaintiff a lot of monetary damages, and you do not want to be wrong on this one. So please do what we're saying, and if you refuse to do it, then we're not going to be able to defend you. Call ODS if you disagree, and do provide that accommodation while any appeal is pending. Learn that students can schedule their test online through this clockwork test scheduling, and there's a little video online that tells you how to do that, so go look at those websites. Don't ask a student who brings a dog into class if they have a notice from the Office of Disability Services. There's this quirky little rule in Department of Justice and the regulations that say if you need a service animal, you don't have to go register with the Disability Services. There are 2 questions and only 2 that you can ask a student who brings a dog to class. Is the dog required because of a disability? What work or task is the dog trained to perform? That's it. Nothing else. They don't need a notice. It doesn't make maybe logical sense because all the other disabilities get registered. Just trust me. These are the regs. Don't ask anything but those 2 questions. All the time when you've got questions about these issues, you're going to call the Office of Disability Services. As far as note takers, that's going to be a common accommodation. We have a process now online to ensure the confidentiality of those notes. You're going to not identify the student in the class, but you're going to ask for volunteers in your class who would be a note taker. You're not going to identify that student. You're going to create a folder in the Box account for each course that a student needs an accommodation. You're going to send a link to the note taker so they can upload their notes, and you're going to separately send a link to the student so they can access the notes, and the note taker who does this will receive a $100 stipend on their action card. So if you're having trouble recruiting a note taker because you need one in your class, please contact ODS and ask them for other tips. But again, it's not ODS's job, it's your job to get that done. And work to make sure that your websites, YouTube videos, etc., are captioned and accessible. We have a whole office on campus now, our Technology Accessibility Support Office, that can help you with that. So those are some of the things that you can do. Here's a slide that gives you a lot of contact information, our Office of Disability Services, the emerging technology and accessibility for captioning, and then each college has a Section 504 ADA liaison. If there's a complaint that's because we haven't done this right, that's going to be directed to Dr. Gwen Hood, who's our UA ADA 504 coordinator. If you're an employee and you need an accommodation, I told you earlier we have a one-stop shop. You can go to this website. You're going to go basically to the same person in HR who's going to handle a pregnant employee, a religious observant, or employee with a disability. It's Emily Marbut, but you're going to contact the HR Service Center and fill out the paperwork, and you'll be on your way to having some dialogue to determine that. All right, we're going to fly through. How are we doing? Okay. Good. Okay. All right. FERPA. We're going to take questions at the end, by the way. FERPA is Family Educational Rights and Privacy Act. That is the law that regulates the privacy of your student records. And the fact that you're actually a GTA is actually a protected status. We can't go tell the world unless you give us consent about that. Reasons I want you to know it is one, the faculty handbook says, and it applies to faculty and staff, and it says that you have to know this policy and you have to observe appropriate precautions when handling student information. So it's our own internal policy, plus it's the law, and we want to avoid an investigation by the Department of Education Office of Chief Privacy Office. That's the group, I call them the FERPA police in Washington. They're the ones that can come down and investigate us. That's who a student would file a complaint with. The good news is they can't sue under this statute. They might sue for a tort claim, a breach of privacy claim, but they can't sue in federal court and get attorney's fees, so that's a positive thing. But the worst thing possible is that Department of Education could fine us and could also take away our federal financial assistance, meaning all of us on loans would not be able to go to school. And I also want you to know these rules so that you'll feel comfortable sharing information when you can, so that we can avoid situations. You're going to hear the Virginia Tech situations, the active shooter, somebody's in your class who's acting really strange and declining, and you'll get experts talking to you all day today about that. I want you to understand FERPA so you know when you can tell us about that. And I'm going to tell you, in those circumstances, you can share it with anybody on this campus who has a need to know. Okay, so let's go through some of the rules on that. There is some other UA training available. The registrar has put some incredible information online. One of the pieces of information is on page 58 of your notebook. It's the quick guide for faculty. I went ahead and printed it. It's online, but it's a great resource for you. They have a FERPA fact sheet that has some hints and says, don't use your student ID name and name to post grades. Leave graded tests for students to sort through. We just had that happen by a faculty member. Leave a box out with all the graded, y'all come get it. And so another student who wasn't happy about the grade stole the box and decided to build their case based on the other people's grading to see how. And so don't do that. I couldn't believe that happened. As much as we train on this, people's grades are private information. Don't circulate electronically or in print a class list with the student name and CWID. That's because that CWID can be used in conjunction with their other information to actually order pizzas from Domino's Pizzas, and we've actually had to expel some students who stole because some teacher passed around, put your name in CWID. Another clever student picked up the CWIDs and had a grand Domino's pizza bill. And he's no longer here. Let's see. You want to include, you don't want to provide anyone with list of students enrolled in your classes. Why? Because who's in your class is private information. You don't want to provide anyone with student schedules. If you're an advisor and you're able to print off their schedule, that's private information, unless one of these exceptions that I'm going to talk about. If somebody asks you to write a letter of reference and they give you a resume, you're not going into the records at all to write a reference, so you're good. But if you have to go into the record, your record book, to figure out, okay, I got 300 students, what about this one, and they want me to write you're now in FERPA world, okay? So now you're going to need their consent to write that reference if you're going to rely on any record. All right, so basically under FERPA, there's 3 primary rights. You have a right to review your own education record. You have the right to seek to amend your education record, and you have the right to limit your disclosure of your education records to third parties. And there's a lot of legitimate exceptions to this disclosure rule in the regulations, and it's also in our policy. If you really can't sleep at night and you want to get online and read it, it's all there, but it's very boring. We're going to cover 5 of them, okay? The 5 that I think are the most important for you. Before we get into what those exceptions are, you first have to understand, what does FERPA protect? FERPA protects records, okay? Files, documents, other materials that might be in a database, it might be an email, the grades, whatever, that contain information directly related to a student and is maintained by the University of Alabama, okay? Now, there's some things called sole possession records. They might be your own personal note-taking, your own grid sheet when you're teaching, and you're not planning, you don't have to turn it into your department chair, your boss. It's for you. That's called a sole possession record, and that's not a FERPA-covered record, so that a student who has a right to inspect doesn't get to come and inspect your own private little cheat sheets and stuff like that, okay? So there's one exception about that. Also, oral conversations, personal observations are not FERPA records, okay? If you see a student doing something It's not a record. You saw it. If a student tells you something, they told it to you. It's not a record. If you'll remember that one main thing right there, that FERPA is not like HIPAA, going to the doctor, or coming to me as an attorney in an attorney-client relationship. Our conversations when we're in that kind of relationship are privileged. Nobody gets to know them. Same thing when you go to your physician. Nobody gets to know those conversations. That's not true with FERPA. FERPA is only records. So get that in your brain, and that'll help you work through some of the, oh, can I tell the parent about this? If it wasn't in a record, you can tell them everything. If you have a small class and Susie hadn't been in class all week and parents calling you, you can tell them Susie hadn't been in class all week because you didn't have to go look at a record to determine that. Okay, so that if you can get that in your brain, it'll really help work through some of the things with parents. Caution about emails. You may have a difficult student, and you are sharing it with your friend, which you really shouldn't be doing, but it's another GTA, and you're seeking advice on how to handle it, and you wish it's one of those emails you wish you hadn't written. It was brutally honest. Realize that record, that is a record, is a document, it's an email that has a student's name, and it's maintained by the university on our servers. That is a FERPA record, so if a student asks to see their record, they could see that email. The point here is be cautious about what you write in your emails. If you don't have to email and you can just talk about it, that would be the safer thing to do. Don't retain emails that you don't need to keep. Get out your frustration, you got it out, delete it, okay? Sometimes I email myself to get it all out, and then I just delete it. It makes me feel better, and it might make you feel better. So you're gonna have to keep an email as confidential and secure as you do their grades, okay? Because it's a FERPA record. Beware, too, of student phishing scams, okay? So, and this is more to help you with security. Beware of those emails coming to you that you don't know what they are. Pay attention to what OIT sends you on this. If you click on something that you shouldn't have clicked on, and we get some ransomware and it encrypts all our shared drives, everything you've got access to, it's a really big, messy thing. So just be careful about that. It's not really FERPA. I just threw it in there to get a little training on that. All right, so when can I disclose information? What are those 5 exceptions I want you to know today? Anytime a student gives you written consent. The consent's got to identify the records to be released and to whom, the purpose for the disclosure, a student's signature, and a date. That's it. It's very simple. If you're in the medical field and you know about HIPAA, there's like 16 different things that have to be on that form. Not true. This is not true with FERPA. It's very easy for a student to give consent. The registrar's office tracks the consent to parents or guardian, and let me tell you, on page 51 of your handbook, I had the registrar's office prepare a one-sheet on if you had to go into Banner and go look for that record, where would it be? I'm not smart enough to know all that. It's there as a resource, okay? So what you want to do is, if you're talking with a parent, you're going to want to, well, we'll get to that in a minute. I just realized I had some slides. But basically, you're going to want to teach the parent how to teach the student to give consent to the parent, and it be tracked in our Banner system. So get consent, that's always safe. 2 is directory information, and directory information is anything on this slide. Okay, good. Anything on this slide is directory information, and we can give it to the Tuscaloosa News, we can give it to CNN, we can give it to anybody, unless the student has put a hold on their records. Okay, and this applies to you and your student status too, okay? We may, less than 0.05%, I'd say, put a hold on their records. They might be in some witness protection, or parents are in a nasty divorce, and one parent, they don't want somebody to even know where they are. It could be a protection from abuse kind of situation. It's very rare, but Banner tracks whether or not someone has put a hold. So if there's a hold and we released even this kind of non-threatening information, we would be in violation of FERPA. So you got to check with Banner, but it's not harmful if we release the names. So you could release somebody's name, but you just can't say they're my student, because if you see on there, the class they're taking is not directory information. okay? So name, address, email address, just things that aren't harmful if they were released. A third exception, which is going to be the one that probably got Virginia Tech in trouble because they didn't realize they could share. If there's another employee on this campus who has a legitimate need to know, if I'm the lawyer and I call you and say we're dealing with a matter and I need to see the records, and I've done this before, and the GTA had been to the training and actually said, well, let me check with my supervisor, and did not just respond to me. And I thought that was an absolute, I thought, yay, points. You shouldn't. If you're not comfortable, if you don't know who I am and I'm calling you for records, you better check it out with your supervisor. But we can have access to your records if we have a legitimate business need to know. I had 2 children who went through this grand university, and I would have been in violation of FERPA if I had called the graduate school and said, would you tell me how my kid's doing in grad school right now, or whatever. You can't use it for things that are personal. It's only do you have a legitimate business need to know. So you're going to get academic advisors asking you questions. The athletic department might be asking about a student athlete, your department chair, your deans, our office, internal audit, the provost, etc. We all have the right to know. You're going to hear from some just UAPD, from our threat assessment team, Charlie Dorsey, that those people are going to get to know. Why? Because they have a legitimate need to know. The fourth one is the big one with parents. That's what I meant when I said turn to page 51 to see when a parent has how a parent can help their student give consent through Banner. But I want you to know this, and this is hard for our parents, when they're in K through 12, the right to inspect records and all the FERPA rights belong to the parent. Once they come to the University of Alabama, all those rights transfer to the student. So parents have no rights. But somebody forgot to tell them that. And we're the messenger, and that's not a happy message for a parent. That doesn't mean we never give information to the parent. We are permitted under FERPA we're permitted to give information under these certain circumstances, but it's not a right. We can say no, okay? That's what they don't quite understand, because in K through 12, they had that right. And it doesn't matter if the student is 12 years old. If they're enrolled here, the right transferred to the student. So first concept, parent does not have a right to it. So when can we give to the parent? When the student gives consent. So that's what I meant when on page 51, that tells you how you can go in Banner and look at that. So just tell the parent, the student can do this online, tell them to go to their MyBama account, and the student knows that. But that'll then show up in the Banner record, and you'll know how to look at that. We can also disclose if the parent has declared the student as a dependent on the tax return. The problem with this exception, practically speaking, is I don't want you asking them for their tax return. I don't want you to have to maintain that. It's messy. So it's academically, that's another exception. But that's why we built the consent form into the MyBama portal, so we didn't have to collect tax returns, okay? So know that that's true, and most 99% of our freshmen are declared as dependents. But we can't presume, or we can't take the parent's word. We'd have to have the student tell us, and then it's only good for that tax year, okay? So really the better route is to get the consent. We can also disclose, and this is less likely to apply to you, but if they are in trouble with us because of a violation of a drug or alcohol and they're under 21, we can write the parent and tell them about it. That's not going to be something you all are dealing with. Our student affairs folks will deal with it. Here's the big one I want you to know about. You can always, always, always disclose a record about a student if it is a health or safety emergency and you need to tell that person to help alleviate the health or safety, okay? Remember that when you personally observed or heard the student say something that created this emergency, remember that's not a record. You don't have to even worry about it, okay? I would rather defend a FERPA violation than a suicide case, okay? Or some kind of active shooting. I'd rather defend this smaller FERPA violation if we're going to weigh. And I'm going to tell you, there's an exception for you, but if you're nervous about it, know that there's this health and safety, and I'd rather deal with the FERPA violation than you mess mess up and not tell someone who should have known. You want to contact UAPD immediately if there's an immediate threat or imminent threat. Otherwise, you're going to contact the BIT team, and you're going to hear about that later today. In a health and safety emergency, you can always release in connection with the emergency to protect anybody, to keep them from harm. If you do it under this exception, you are supposed to document what you did and just give a rational basis. This was a huge change in the law after the Virginia Tech shooting. The Department of Education construed what it was an emergency very narrowly and would really, look at it in hindsight and threaten institutions for releasing information. Virginia Tech changed everything on this exception. They changed the rules and said, we're not going to second guess your judgment, just document it, and all you have to have is a rational basis. That means a million other people could disagree with you, but it was rational, it made sense. The majority may not have agreed with you, but as long as it was rational, it's good enough. Just document it. Who can be told? Anyone that can help resolve the situation. So the regulations say current or prior peers of the student, mental health professionals, law enforcement officials, the potential victim and parents of a potential victim, other schools that the student has previously attended, and a threat assessment team, and you'll hear about that soon, and parents. Those are all specifically named in the regulations, so you're good to go. So that's the end of FERPA. How much time am I dealing with? Got a little bit of time? 10 minutes? 5 minutes? 7, okay. All right, real quick, the Code of Ethical Conduct. The Board of Trustees of the university asked all 3 of our campuses to develop and mandated that we have a Code of Ethical Conduct. So ours are really, it's a broadly worded policy, and it really refers back to a bunch of specific policies. But here are the 8 standards. Provide quality education, research, business interactions, healthcare, and other services. Treat individuals with respect. Comply with applicable laws, regs, and policies, and you've heard about some of them today. Use confidential information responsibly. Acknowledge and appropriately manage conflicts of interest. Safeguard and accurately account for UA resources. Provide a safe environment. Document, code, and bill and collect in accordance with rules and regulations. And then there's some appendices to that policy. It's probably a 5-10-page policy, and I summarized it in one here. It then has a bunch of links to all the different policies. So be aware that there is one. Here's the main point I want you to know about it, and it gets back to this anti-retaliation. In the last paragraph of that policy, it says that university community members are required to bring suspected violations of laws, regs, policies, and standards to the attention of the appropriate office. You've got to tell us about it. Notice of suspected compliance violation is treated very seriously. We also have a hotline complaint. It's on that website policies list of important policies that I gave you. The link is there. It's also on the UACT chart. If you don't want to call somebody and tell them who you are and you want to do it anonymously, we have a hotline for you to do that. The important thing is you tell us about whatever your issue is that you think we need to know. UA community members are prohibited from retaliating against you or allowing retaliation against you if you've reported activities for violating laws, regs, or UA policy. And obviously, if we learn that somebody has violated the anti-retaliation provision, as I mentioned earlier, is one of the biggest charges in the country for EEOC, you will have consequences if you are the one who is retaliating. Finally, the compliance with our state ethics laws. If you will flip to pages 52 to 55. This is a handout I created a few years ago because I just got tired of good people who didn't know what they were doing was wrong. And I thought, okay, and most of the presentation today are situations over my 29 years here. If I'd have just told somebody, maybe we could have avoided it. So that's what the point of that handout is. A lot of it may not apply to you because you're a student employee, but a couple highlights that I want to point out. If we learn that you have violated our state ethics code, it is a mandatory report. The president of the university is in trouble, and I'm in trouble, and our office is in trouble if we do not do the mandatory report. We can face a criminal charge. So we have to report. That 4 pages is going to cover all that information, a lot of our policies, okay, that tie back to this. But one that I want you to be aware of, state employees cannot sell their football tickets for a price greater than what they paid for, okay? So most of you probably got your tickets by being a student, so you're okay, you're not an employee. But for those of us who are employees, we cannot sell our tickets that we paid $25 for, we can't sell them for $100 and make a profit, okay? If they find out about it, mandatory report to State Ethics Commission and you're facing a criminal charge and we can't defend you. Faculty can't use their own textbook unless it's approved by a textbook selection committee. So you all may be brilliant. As a GTA, you're writing your own materials and you want to sell them to the students, and so you have 500 students in your class and you charge $50 pop. You can imagine the profit that you would be making. We actually had that situation occur. It was with a faculty member who failed to go through the proper process, and therefore he lost his job and he's been criminally prosecuted, or at least they brought charges. I haven't kept up with what happened. Serious charge. You cannot, here's the whole point of the ethics code, you cannot use your state position for your personal gain. So if you write a textbook and you sell it to your students and it hasn't been approved by a neutral body as, hey, yeah, that's really the best textbook, then you're violating the ethics code. You can't use UA property or employees for personal gain. And let me make a point here. You cannot be used as a personal slave to your boss, okay? That means GTAs don't become, for faculty advisors, the babysitter, the apartment, you know. This is a real situation. Tenured faculty member lost their job because for years it was being abused. They were abusing GTAs and we didn't know about it. Finally, somebody told us about it and we were able to do something about it. You're paid by the state, you're paid a salary, you've got to do work. That doesn't mean every now and then they say, return this to the library. That's not what I'm talking about. I'm talking about babysitting. Come pick me up at the airport in Atlanta, and you feel like you have to do that. If that's happening, you need to contact. You can use the hotline if you don't feel comfortable telling us about it. And then finally, you cannot accept a gift from a student to corruptly influence you to give you a better grade. I have a daughter who was a student and she's never heard my training, and one of her teachers was in this training session, and she likes to bake, and she baked all her professors' bread. And it was the cutest little thing because it's like elementary school, but we're in college now. But she did it anyways, and the professor had been to the training and declined the bread. And my daughter was just so confused, and I had to explain to her this ethics law that she probably could have accepted the bread, but she was being absolutely just straight up, I'm not going to even take a gift because I don't want anyone accusing me of taking it for the wrong purpose. But generally speaking, there's now a limit in the statute that says you can accept a gift up to $25, but you never can accept one if it's to corruptly influence your grade. So I actually finished slides, and I have time for questions. This is a miracle. I just want you to know you witnessed it because this is not my expertise in staying within time limits. All right, questions. And I think there's some microphones right here. Oh.
So everybody doesn't get up and go.
Yeah, don't get up and go.
Don't get up and go. So guys, just want to let you know that we had missed putting in the little break this morning on the agenda. So hang with us. We'll finish up with Ms. Lemley. We have a next presentation, and following that, you will have a nice 15-minute break before we head on to the last two things before lunch. Can you hang on? Okay, thank you so much.
Okay, questions. And usually they have a mic, so are they supposed to be running around with the mic? Okay? No? Do we want another one? Does somebody else want another one? You can scream it out, but I'm not going to be able to hear it. And I want the whole audience to hear.
I have a two-part question. First, I'm wondering whether there have ever been any false accusations from a student to GTA.
Yes.
And what that situation was. And two is, are there any rules and policies as it relates to office hours? The GTAs are going to have office hours. And in light of the climate we're in now, should it be open door? Should it be closed doors? How should we handle that?
Great questions. On the second question, you're going to be required to have office hours? I mean, I would make sure that your door is cracked. I would not put myself in that situation of having a closed door. If it's very sensitive, if you've got a window in your office, that's helpful. I'd also document your conversations that might be sensitive with the students. The other one was, the question he asked was, have we ever had false accusations? Surely not. Yes, because they're human beings and there are kids who are in trouble and they make up stuff. It doesn't happen often. It really doesn't. But it has happened. The case I told you about where the department chair was in a relationship with a student, the court agreed, and the university got out of that case, the department chair got out of that case. It was messy getting there, but the student had really set up the professor, and we learned that the same behavior had occurred at another institution. So yes, students are going to make up things. On the ODS, for students with disabilities, they're going to say, you never told me where to go to get an accommodation, and hopefully when you got your accommodation notice, you're going to document the fact that you got it on this date, so if it's halfway through the semester, you know you didn't get it for the first 3 weeks. And I heard a great suggestion earlier, call the disabilities office and say, hey, I just want you to know that I didn't get this accommodation notice from the student until today, and we've had 3 tests, and now he wants me to erase those grades. So the whole point of this is document, and that will help you defend against false allegations. But yeah, it does happen. Not frequently, but it has happened. Okay, question here.
So what do you do if there's a student who's filed harassment charges and asks you for a letter of recommendation, but they don't deserve a good letter of recommendation? How do you handle that situation?
So they've filed harassment charges against you?
Well, just in general, I mean, you said that someone
Yeah.
files harassment charges.
Yes. Okay, so if anyone files harassment charges, you can't retaliate against them by not giving them their reference letter. Now, separate and apart, you got to be honest in the reference letter. Now, you got to make a choice. You want to be true and accurate, but can you focus on the positives? You cannot ever hold it against somebody who brought a harassment charge. You just can't. You have a right. Think about if it was your daughter, your son who was undergoing the harassment, and then someone was going to punish them because they tried to do something and did the thing that you taught them to as a parent, to stand up for yourself. You cannot retaliate. No matter how much you disagree with the merits of the case, you cannot do that. Question over here. Oh, there's one in the back.
Hi, my question is regarding the service animals. If someone has a service animal that they're trying to bring into a laboratory setting, are there any additional safety precautions and accommodations we need to make for the animal?
Yes, you have to actually read the whole assistance animal policy, and there's a lawyer in our office who's much more well-versed on that than I am, but there may be labs where the dog cannot be allowed, so we would have to come up with another accommodation. But that's usually going to be, now you're talking to ODS, and ODS is talking to Katie Thompson in our office, who's the expert on this. So good point that there are some situations. There's a whole bunch of other rules about dogs. If the dog is biting people, we don't allow bites, or doing their business, we don't allow that. They have to be under the control of the handler. So there's a lot more rules associated with that. Again, you can look at the animal assistance policy. Got a question in the back?
Hi, yeah, with the Title IX reporting.
Yes.
So if someone comes to you and says, I have something that I wanted to talk about, and then you say, I'm required to report what you say.
Can you talk a little louder? Because I'm
sorry. If someone comes to you and says that they wanted to talk to you about something, and you tell them, I'm required to report this, and then tell them, these are the other options you can do, and they decide to go somewhere else to report it, do you have to then go to Title IX and say a student came to me to
Yes.
talk about an issue, even though they didn't tell you any details?
Yes.
Okay, so what do
Okay.
you then report to Title
and
IX?
you're just going to, exactly what you just told me.
Okay.
Okay? So what's going to happen is the Title IX office is going to reach out to the student. And they're not going to force the student at all. They're just going to send them an email and say, it's come to our attention that you may have something that you may want to report. We're here to help you. They might do that 2 or 3 times, and then they'll leave them alone, because it's up to the complainant to actually pursue anything. We have to respect those rights. Okay, question up front. One more. And I'll stay and hang out in the back there, or stay up front, wherever, and
How I interpreted a previous question was not whether there's a harassment charge filed against you and then a student asks for a letter. It's if a student asks for a recommendation and they're undeserving and you decline to give a recommendation and then a harassment charge is brought against you for that declining to give a recommendation. How is that handled? Are we
Okay.
allowed to decline recommendation?
yes, you're allowed to. Okay, I'm sorry, I misinterpreted that. Yes, you're allowed to decline giving a recommendation, but you better be able to articulate a non-discriminatory, non-retaliatory reason why. Is it your policy that you don't? Or that you just tell them up front, here's the reasons why I can't give you a positive recommendation. If you still want me to write one based on this knowledge, then sure, I'll be glad to proceed. But you can't not write letters of reference for people who file harassment claims. You have to treat similarly situated people the same. Okay. Do we have one more? I'm hearing one more.
Okay, so my question is in regards to the service animal. So say if we have a student that has, that needs a service animal, and then like another student is actually like allergic to that animal, like how do we?
Yeah, and that
Procedure.
happens in our dorms, obviously, or not dorms, residential life. We're going to have to accommodate both. So what you're going to do is you're going to call ODS, and ODS is going to help you work that through. We may have to do some reassignment of classes and put people in different sections, move them in the classroom. I don't know what it will be, but we're going to have to resolve the allergy problem and the dog accommodation policy. Okay, I'm going to hang out, I guess, in the back, and we'll answer questions. Y'all have been fabulous, and I just wish you the best of luck. Thank you so much for paying attention.